We are here for a hearing in the matter of CFI 027-2021 and CFI 028-2021 before Justice Wayne Martin. The hearing on these applications is being held by way of video conference. Any orders or directions made after or during the course of this application will be issued by the Registry in Dubai on Justice Wayne Martin's instructions. The claimant's lead counsel is Sean Brannigan QC. The defendants are represented by Clyde & Co. Lead counsel is Anthony Jones.
But thank you very much. Well, Mr. Brannigan, it's your application, so would you like to address me?
Certainly. Good morning, Judge. As you're aware, I represent all of the claimants, if I can put it that way, in relation to two separate but obviously linked actions. That's claim number CFI 027-2021 concerning the defendant Orient UNB, and claim number CFI 028-2021 concerning the defendant Qatar Insurance Company. I represent the claimants in those actions, and my learned friend Mr. Jones represents the defendants in both of those actions. Right at the start, Judge, I can tell you that Mr. Jones and I have spoken offline, and whilst this matter has a full day listing, we both think that we can get through this, if the court's minded to, in 3 hours or so.
Yes. Yes.
The view we've taken is that we should both have approximately 1 hour and 15 minutes each, which will obviously give us 2.5 hours and a float for 30 minutes for any intervention which the court might have at the end, or just to take account of the fact that such is the vicissitudes of life.
Yes.
I intend to spend my time, an hour to start with, followed by 15 minutes or so to deal with any new points which Mr. Jones raises, which aren't in his skeleton afterwards. I don't know if that's acceptable to the court, but that's
that sounds perfectly fine to me. Thank you, Mr. Brannigan, and very sensible. Somewhere in that process, we'll introduce a break, but we'll just assess that as we go. But maybe around halfway through, perhaps after an hour and a half or so, if you're allowing up to 3 hours, you might take a break then.
Certainly, but that does sound very sensible. The court has had from both Mr. Jones and I a skeleton note. I'm hoping that has reached its way to the court.
Yes, Mr. Brannigan, you and Mr. Jones can both assume that I've read the skeletons and all the materials in the hearing bundles. So I've read all the affidavits and all those materials, so you can take that all as read.
Well, I'm very grateful. Well, that obviously greatly assists with the 3 hour time estimate. So what I propose to do with my hour is to start by drawing the court's attention to what we, on behalf of the claimant, think are some of the most salient aspects of those underlying documents. Having done so, then turning to deal with points 1, 2 and 3 as I have raised them in my skeleton. So why don't I start on that basis? And of course, all references which I make are references to the particular page numberings on the online bundle. A useful place to start, well, the starting point is, of course, to recognize what we're here to argue about. We have made 2 linked applications on the 18th of May 2021 for orders that the orders of His Excellency Judge Omar El Mahari, dated 14th of April 2021, be set aside, and the stay in those proceedings imposed by those orders be lifted. As the court is aware, those orders were made without intervention by the parties on the back of the application made by the other side to the JJC. And so really we're here to argue about whether or not there should be a stay in the particular circumstances of this case, if I can short circuit the issues in that way.
Mr. Brannigan, I think both sides are approaching this on the basis that I'm effectively treating the case as a hearing de novo. I don't think there's any dispute as to that. There's no notion of an appeal, and it's also clear that the stay was made at a time when the perception of how the relevant decree operated was somewhat different. Mr. Jones, you don't quarrel with that, do you?
No, not at all. We are asking the court to judge that the orders were properly made and to let them stay. Mr. Brannigan is rebutting that. So.
Yes, that's as I understand it. Well, that's I think a very sensible way to approach it, if I might say, in all the circumstances. Yes, Mr. Brannigan, back to you.
Thank you very much for that intervention, and I'm very grateful to my friend for his confirmation. So the starting point obviously should be, as it is in most cases, to have a look at the underlying claims that we are talking about. The claim form you will find, and they're in virtually identical format, so I don't intend to take you to both of them, given you've had a chance to go through the bundle. But if we just take the claim form in what I'm going to call claim 27, as opposed to claim 28, which is the Orient claim, you will find that claim form at bundle C, page 1 onwards.
I've got it. Thanks, Mr. Brannigan.
So the you will of course be familiar with the format of these claim forms. The meat of the claim form begins at the bottom of page C2 and then carries on over C3 and C4. The salient features which one picks out of this, in my respectful submission, are that you can see that at C2 the two claimants for the purposes of the DIFC proceedings are identified. The first claimant, which is the holding company of the second claimant, and which I think is now common ground, is a company incorporated under the DIFC, is the first claimant. At C3.
Well, just before we leave that, the claim is brought jointly in the name of both claimants, isn't it?
Well, they are both claimants. They jointly bring a claim, but there are going to be different issues will have to be resolved in relation whenever one comes to resolve the claim of both claimants. Those issues can.
Well, there's nothing in the points of claim that differentiates as between different causes of actions. They both claim to be insured under the one policy, don't they?
They do.
And so they can only recover, and the claim is for the limit of coverage under the policy.
It is. But
and so that limit can only be recovered once.
And again, that's absolutely correct.
Yes. All right.
But both claimants have different losses calculated in different ways. But you're absolutely right that they can't claim this. They can only claim the same amount due under the same policy. But each of them will have to establish their loss, and each of them will have to establish that that loss is one that gives rise to an entitlement under the policy.
Well, the first claimant is the holding company of the second claimant, isn't it?
Yes, it is.
And didn't conduct hotel operations in its own right.
No, it didn't. But there are, and they weren't.
Well, therefore, its losses can only arise from the losses that were suffered by the second claimant, can't it?
Well, there is a complicated set of agreements between the first claimant and second claimant. I don't think it's absolutely correct to say that its loss is purely reflective upon losses suffered by the second claimant.
But if the second claimant is fully indemnified for the losses it suffered as a result of the business interruption, then the first claimant will have suffered no loss. That's right, isn't it?
Yes, I think that is correct. That if the second claimant is fully indemnified, it will not suffer. But having said that, I don't think there's any danger of the second claimant being fully indemnified.
Yes.
Because I mean, it's not a matter that can be resolved, I completely accept, for the purposes of today. But certainly the second claimant's losses, it says, are significantly more than the cover available under the policy.
Well, if that's right, then the second claimant's claim for 25 million will exhaust the cover, and that no question will arise as to whether the first claimant has a claim or not.
Yes, but equally, it is theoretically possible. Now, we'll have to see how the defendant develops its arguments, particularly on the back of the complicated guidance there has been emerging from England and some other jurisdictions as to how these policies should be construed. But it is at least theoretically possible that different issues will arise in resolving the first claimant and second claimant's claim to that policy in terms of their insurable interests and so on.
Yes,
Not because different terms apply. There's only one, in each case, there's only one policy to be construed and applied. But it must be theoretically at least possible for there to be different defences made to the first claimant's claim and the second claimant's claim. And in fact, as we understand it, that's exactly the case. There are separate defences made as to the extent to which the first claimant does in fact have an insurable interest, and the extent to which the first claimant has an insurable interest which is covered by the particular policy. But you're absolutely right, and I don't shy away, Judge, from the fact that if the second claimant is successful in full in this claim, it will exhaust the policy. That's undoubtedly the case. But that is not the same as saying that the two claims are coextensive or should be treated as coextensive for all purposes, because they aren't. Different issues arise in each, and it is theoretically possible that the defendant will be successful in seeing off some of the second claimant's claim, but not successful in seeing off some of the first claimant's claim.
And there can't be any conflict of interest as between the two claimants, because otherwise they couldn't sue in the same proceedings, could they?
I think that's right. I haven't applied my mind to the conflict of interest point precisely because, as you indicate, Judge, at the minute I can't see how there could be a conflict of interest between the two.
Well, if there is, under conventional procedural arrangements, they couldn't jointly sue if there was any conflict of interest between them, could they?
Well, I'm not trying to be difficult about it. But because you asked me the question directly, I'll give you a direct answer. Theoretically, they could, if the two claimants had between themselves worked out how any such conflicts would be addressed and dealt with. But I am not aware that there is any conflict, and so I'm not suggesting that theoretical possibility is correct. I'm only saying theoretically they could because you've asked me the question directly, and I think that directly that's the most accurate answer.
All right, thank you.
So I can well understand, of course, Judge, why you're asking these questions. It goes to the point of what happens in a situation where the defendants have chosen to refer one element of this, i.e. the second claimant's claim, to the JJC, but not the first claimant's claim. So I completely understand why you're asking the question.
Well, that's one way of looking at it. The other way of looking at it is it arises because two claimants have chosen to bring a claim in one court, and one of those claimants has chosen to bring the same claim in another court.
Yes. That's another part of the fact pattern here, and I completely get it. It goes to the same central question, which is how one resolves that issue. I get that. It's apparent from the question that you've looked at this claim form before. Suffice to say that at C3, the first and second claimant both assert that they have loss suffered, and the remedy which is claimed at C9 is at C9, which is a remedy in which, as you've already observed, they are claiming in effect the sums which they say arise under the policy, and in effect declarations as to what the relevant insurance committee in Dubai should have done. Yeah, so you see that under remedy sought, the claimants request the court to grant the following relief: to order the respondent to pay an amount of 25 million dirhams, or such sums as the court finds due in favour of the claimants as the stipulated insurance coverage, to order the respondent to pay legal interest at rate of 9%, further alternatively to reverse the decision of the insurance committee and hold the respondents liable, and order A and B above. C is obviously, though it isn't, the word declaration isn't used, but that's obviously what C is asking for, a declaration to that effect.
And the prayer for relief doesn't differentiate between the claimants?
It doesn't differentiate between the claimants.
And so when default judgment was granted, it was ordered that the judgment was entered for 25 million dirham in favour of both claimants, wasn't it?
That's correct.
Both claimants jointly. Yes.
Yeah.
Right.
As I construe the default judgment, the 25 million, the obligation is to pay it to both claimants. But of course, if it was paid to one, that would exhaust the liability. It wouldn't have to be paid a second time, obviously, to the other.
Yes.
So that's the proceedings of the DIFC. As you have picked up, Judge, in the Dubai court proceedings, the first claimant does not feature in either proceedings. That is accepted, as I think it has to be, at paragraph 6 of my learned friend's skeleton for today. If it wasn't accepted, plainly it's the case. One only has to track through, as I have tried to do in my skeleton argument, the various documents and look at them in the Dubai court proceedings to see that that's the case. But at paragraph 6, it's accepted. The interesting thing about that is that having accepted that reality, that the Dubai court proceedings do not involve the first claimant, that is either ignored or misstated at both paragraphs 10 and paragraph 12 of my learned friend's skeleton, in which the fact that the first claimant does not form any part of the Dubai proceedings is either relied over or misstated. At paragraph 10, my learned friend talks about the day after filing of their acknowledgements of service at DIF court, the defendants filed applications to the Dubai Joint Judicial Tribunal seeking determinations of which set of courts has jurisdiction over the claims brought against the defendants in respect of the claim for indemnities. As we'll look at in a second, that's not quite true. They referred the claim brought by the second defendant, the second plaintiff, but not the first. And in paragraph 12, the skeleton indicates, against this background, with the claimants having commenced proceedings against the defendants in both the Dubai courts and the DIF court, again, that's not quite accurate. It's only the second claimant who has brought the proceedings.
What is the forensic justification, if any, for the course that's been followed by the claimants? And as I understand it, in chronological terms, the first proceedings in point of time were the Dubai onshore proceedings brought by the entity we're calling the second claimant in each case. Is that right?
That's
correct. Yeah, and then a few days later, the proceedings in this court were brought by both claimants in each case.
That's right.
What's the forensic justification for that course? Is there any?
Well, it depends what you mean by forensic. The reason why the DIFC entity of the first claimant was included in the DIFC proceedings is that the view of those who instruct me was that was an appropriate course to take, given that these were DIFC court proceedings.
Well, without the first claimant, you would have had serious jurisdictional problems, because the first claimant is a DIFC body, so it's obviously there to give you a jurisdictional hook. But that's not really the point. The point of my question is, what is the justification for commencing parallel sets of proceedings in two courts at approximately the same time?
I think I don't know the reason why that was done, so I can only speculate. I think it was in case there was a jurisdictional argument taken in some way to maximise the prospects of being able to get the proceedings on foot. I think that's what it was.
Is there any basis upon which a jurisdictional argument could be taken in the onshore Dubai courts?
Well, yes, there is.
What is that?
Well, one, for instance, is that the appeal which lies from the relevant insurance committee is described to be an appeal that lies to the competent Dubai court. We certainly take the view, upon advice, that the competent Dubai court for these purposes should be considered the DIFC court.
Why?
Because it's an English wording policy brokered by brokered by an international entity that covers inter alia DIFC entities, and in those circumstances, and just the reasons really are set out in the third point within my skeleton. For all the reasons we set out there, we're either right or wrong about this, but certainly our contention is that in fact the DIFC court is the correct jurisdictional court for this.
Right. All right. Well, nobody has the defendant in the onshore Dubai proceedings hasn't taken any objection to the jurisdiction of that court, have they?
No, they have not. That's correct.
Right. Well, so the result then is they have, after the default judgment was entered, they have it indicated. I mean, the problem is that you've got two horses running at the same time, and that's, on the face of it, arguably an abusive process, isn't it?
Well, the problem with the abusive process point is that we have tried to shoot one of the horses, but have not been allowed to.
Well, but that's, let's go back to the preceding. Before you tried to withdraw, wasn't there a strongly arguable abusive process point? Because you'd commenced proceedings against the same defendants in two courts. And the position, let me just read to you a passage from a recent decision. At the risk of being parochial, I'm afraid it's a decision of the Australian High Court, but they're the ones that I'm familiar with. But I think
don't worry about that.
The principles are pretty straightforward, and it comes from a recent decision of the High Court. The case is Wigmans, WGMANS, against AMP Limited, and it's 2021. Media neutral citation is HCA 7. And the Chief Justice and Justice Keane summarised the principles this way, and I don't think they're controversial. They say, and this is at paragraph 14, accordingly, where multiple proceedings are brought by the same plaintiffs seeking the same relief against the same defendants, if the plaintiffs do not make an election as to which action should proceed, the court will stay all but one proceeding. And Old English and Australian authority is cited for that proposition. And the next sentence is, where the plaintiffs do not make the election, the court will stay the proceedings brought later in time, unless they offer some legitimate juridical advantage for the plaintiffs or the defendants over the proceedings brought earlier in time. And I suppose you're saying, what you're putting to me, I understand, is that the legitimate juridical advantage that was sought at the time was against the possibility that an objection might be taken to the jurisdiction of the Dubai onshore courts. Is that right?
Well, there's 2 points I'd make. First, in relation to the juridical advantage, there are two advantages. The one you have just indicated, that advantage was an advantage at the time, but has now fallen away, given that no objection is taken. Yes. But the second advantage is the fact that we have a separate claimant, and so therefore theoretically, even if some points are able to be taken in relation to the second claimant named, the first claimant has got its own separate entity and its own separate points, and it can take those points.
But that claimant could have brought proceedings in the Dubai onshore courts, couldn't it?
It could, I guess, theoretically have done so. But as we can see from whenever we look at the JJC, at what the other side have said to the JJC, that may have increased the chances of the other side taking a jurisdictional objection. Because certainly in front of the JJC, one of the points which the other side have made is, well, look, in the Dubai courts, the only claimant is a Dubai registered claimant. There's no DIFC registered claimant. And so obviously the correct jurisdiction is the onshore Dubai courts. That tells us that, and tells anybody looking at it, that plainly if we had commenced in the onshore courts with the first claimant there as well, that would have increased the chances of a jurisdictional objection in those courts. All right. Because that's precisely the point they make. But the second point I'd make is this. The reason I use the fairly grotesque analogy of shooting the horse is precisely the point which has just been emphasised in the case read out to me. We have made an election.
Yes.
Right. have been very clear in that election. It isn't an election that has simply been made in a letter saying, well, there's these two proceedings and we in fact elect to go forward with one and not the other. We have positively sought to withdraw the proceedings in the Dubai onshore courts. And the only reason why we've not been successful in doing so is because the defendants have protested against that and said, no, that should not be allowed to happen, and have successfully sought a stay.
Yes, all right. Well, I must confess, I'm guilty of, I think, distracting everybody from the real point in the case, which is whether under the relevant decree there should be a stay, because as I understand it, no stay has been applied for on the ground that I've referred to. The only basis upon which the stay is said to be maintainable is pursuant to the decree.
That's correct.
So the point I've just raised is as I say, a distraction for which I apologise.
Oh, you don't need
but it was just of interest to me, that's all, and so I got a little bit anyway.
Well,
but the case will turn on the proper construction and effect of the decree, I think.
Well, I think it does. Let me just say, I always get slightly worried when a court apologises to me, because it always, if I may say, without any disrespect, means that the knife is slowly sneaking around the back.
No.
Anytime a court apologises.
You can't see. My hands are above the table, Mr. Brannigan.
Any judge worth his salt can insert the knife without the hands once flickering.
All right. Now back to where you were.
Back to where I was. But the reason why I flag all of this up is precisely because of the point which you make about the decree. The stay is sought on the premise that the claim made by these claimants, plural, has been referred to the joint committee, and therefore a stay is appropriate. But the point is that is absolutely not what has happened. If I can bring you, and again, they're both in relatively identical form, just because it's claim 27 rather than 28.
Yes.
Let's look at claim 27, the Orient claim, which you will find the reference that has been made to the Judicial Tribunal. You'll find it M1. And if, Judge, you want to just, by all means, if you think, well, I better just check and make sure it's in the same form, the reference in 28 is made in N1 onwards. But they are, in effect, so far as I can see, in identical form.
Yes.
So at M1 is the front page.
Yes, I have it. Thanks.
Now, there is one reference you will find to the first claimant, which we will find at M9. And I will make my way through this, and so we will eventually find ourselves at M9. I say that because I never want a court to think I've said something misleading or tricky along the way. So as we go through this, there is a reference to the first claimant at M9, but we will see when we get there that we say that reference helps my case rather than hurts it. So point one, the defendant respondent to my application has made a positive choice not to refer the claim made by the first claimant to the tribunal. It has made it, and it's done this in relation to both claim 27 and claim 28. It has chosen to refer only the claim made by the second claimant in each case. And so we can see, for instance, that in the first page you will see the respondent is named as the 5 Hotel Jeremiah Village, formerly 5 Hotel Management LLC. You can see at the bottom of M1, it is asking the tribunal simply to consider the case filed by the respondent, i.e. by that single claimant, against the appellant. That is then repeated halfway through the first box at M2, in which the defendant says, after having his complaint dismissed by the insurance authority, The respondent 5 Hotel Jumeirah filed case number blah before Dubai courts requesting the cancellation of the decision and issuing a new judgment. We then say at M3, box 2, the respondent is mentioned again. At box 3, it says the appellant issued to the respondent the insurance policy. No mention again of this claimant. Over the page at M4, under paragraph 6, says the respondent appealed the aforementioned decision of the committee. At M5, it then makes reference to case 27 filed by the respondent before the DIFC courts. Now, of course, we know it wasn't just filed by the respondent, as so named. So there is, I think, 4 or 5 occasions there that I've just taken you through where the defendant has decided not to make any mention at all of the claim which is made by the first claimant in these proceedings. We then get a bit of the law. We look at M8 to look and see the points which are being relied upon in front of the committee. And we see in the 3rd box down, the aforementioned indicates that cases whose subject matter is an insurance claim shall be considered by the court in whose circuit the beneficiary's domicile rests, or where the property of the insured exists. And then at the box marked 1, 2 boxes below that, sorry, the box just below that, by applying this provision to the present case, the Honourable Tribunal shall find that all the requirements of jurisdiction are fulfilled by Dubai courts rather than DIFC courts for the following grounds. And then it sets out the grounds below. But pausing there, as you know, our case in the DIFC court is that the first claimant was also a party to and has an insurable interest under the policy. That has to be resolved at some point, but the defendants plainly know that that is our case. They have, when referring this case to the joint tribunal, deliberately made a choice not to refer the first claimant as well, sorry, the claim made by the first claimant, and you can see why. You can see that is because they wish to make legal submissions on the premise that the only relevant party is a party which is domiciled in Dubai, because they wish the case to be dealt with in Dubai rather than this court. Now, forensically, one can understand that without in any way denigrating the onshore courts. It will not come as a surprise to you, if I put it neutrally, that sometimes parties prefer to have their disputes resolved by the onshore court rather than the DIFC, and sometimes they prefer the DIFC rather than the onshore court. But so I don't in a way criticize or try to throw bricks at the fact that this is what the defendants want, but there are consequences to deciding only for that forensic reason to refer the second claimant's claim to the JJC.
What are those consequences? You're going to tell me what those consequences are?
Those consequences are that the first claimant's claim has not been referred to this committee.
If the second claimant's claim in the DIFC courts, if the committee determines that the appropriate court for the resolution of the claim brought by the second claimant is the Dubai onshore courts, how could the claim by the first claimant proceed in the DIFC courts when it's brought jointly in the name of both claimants without differentiating their respective rights and obligations, and where both are said to be jointly insured under the one policy? How could that claim proceed in practical terms? Couldn't, could it?
Well, it might be able to do.
Well, the second claimant would be a necessary party before the proceedings, because it would have interests that would be significantly affected by the claim brought by the first claimant.
Well, it wouldn't have to be a necessary party if the second claimant found herself in the Dubai courts then it would. And I've an answer to that, which isn't directly answering your question, which I'll come to, but I always like trying to answer the question directly.
Yes.
In that situation, there would be two separate claimants proceeding in two separate courts.
And one policy, one limit of cover, 25 million. How could it work? Would it be the first claimant to get to judgment wins the prize?
Well,
I mean, it doesn't sound like a sensible system of justice to me.
Well, so the short and direct answer to that is, in that situation, it might be that the defendant or the claimant might apply to the JCC to stay the first claimant's claim. If that was the outcome, if the JJC said, well, we've been asked to consider the second claimant's claim, and it's plain we've only been asked to consider that claim, that's what got them registered with the JJC, and I'll come back to that point in a second. We have now decided that the Dubai court rather than the DIFC court should proceed with that. Then I presume that what the defendants would do in that situation is apply to the JJC for a stay of the first claimant.
Well, why would it have to apply to the JJC? Why couldn't it simply apply to this court and say that the proceedings as formulated in this court are brought in the name jointly, in the name of both claimants? The JJC has decided that the claim by the second claimant can't proceed in this court and will proceed in the Dubai courts. Therefore, the claim by the first claimant can't proceed in this court because the second claimant is a necessary party to any proceedings and can't be a party to the proceedings because the JJC has sent it off to the Dubai courts.
Well, I guess it could. Again, just to be completely, as I try to be, completely upfront, I can well see that if that's what the JJC said in relation to the second claimant's claim, that such an application could be made to the DIFC, and then the DIFC would have to consider it. And it may be that the DIFC would say, well, yes, we are going to stay this until that claim is resolved. But the short point for now is, in trying to deal with the question and faced with us today, is whether at least the first claimant's claim in this court should now be stayed pending the outcome of the JJC proceedings.
Well, the course I've just suggested to you would provide a basis for that stay, wouldn't it? That is, that if the second claimant's claim goes off to the Dubai courts, there would be a strong argument to the effect that the first claimant's claim shouldn't be allowed to proceed. Now, that then means that there should be a stay of the first claimant's claim until it is ascertained whether or not the second claimant's claim will go to the Dubai onshore courts.
Well, the difficulty, so I see the point, but the reason why I respectfully say that the point is wrong is twofold. Firstly, because that would mean that despite the fact that the first claimant's claim has not been referred to the JCC, it is going to be stayed on the premise that somebody else's claim that has been referred might eventually end up in the Dubai.
Well, it's not somebody else's, it's the joint claimant. It's the joint claimant they've proceeded together. It's not as if there's some extraneous third party who's interfering with the claimant's claim. They brought a joint claim. They haven't differentiated as between their respective rights and obligations. They haven't said they've got separate causes of action that are independent of each other. They've brought a joint claim.
Well, I don't think the second thing's, it depends what you mean a cause of action which is independent to each other. They have said that they both have causes of action which are independent to each other that leads to the same outcome.
But they presently have a joint judgment.
Yes, they do. On the basis
let's say that judgment isn't set aside. How could that stand alongside let's say a decision of the JJC that the second claimant's claim go off to the Dubai onshore courts? That claim would be a nonsense because the second claimant's claim has been satisfied in full because of the judgment that's been entered in its favour. So what you say then, well then, if the JJC orders the Dubai courts as the appropriate forum, then the judgment insofar as it is in favour of the second claimant is set aside, but then it would stand, you would say, in favour of the first claimant? it all just starts to sound a little bit like Alice in the Looking Glass, doesn't it?
But the problem here is, Judge, that and the second point I was coming to was that if one approaches it from the perspective of, well, even though they've chosen not to refer the first claimant's claim, but only to refer the second claimant's claim, and have made hay of the fact that the sole respondent is the second claimant, that's good enough to stymie and prevent the first claimant. It rewards the defendant for that forensic choice. It indicates that, well, all you need to do if there's multi-party litigation brought by separate claimants is pick out one of the claimant. Don't seek to stay the other claimant's claim. Pick out one claimant and refer that, the one that's going to give you your best chance in front of the JJC.
But it may be that the course that has been taken by the defendant has been dictated by the course taken by the claimants, and that is that under the decree, only cases in which there is a conflict in proceedings can be referred to the JJC. So the defendant may well have taken the view that the only proceedings in which there is a conflict between the relevant courts are the proceedings initiated by the second claimant. And if that's an appropriate view of the decree, then the only reason the first claimant aren't the subject of the proceedings in the JJC is because you have chosen to commence multiple proceedings with different parties, even though they're both claiming to be insured under the same policy. Do you have any response to that?
Well, the answer to that is surely that what must happen is that the defendant refers the proceedings in full. They say there are multiple respondents. We wish to have you, the JJC, resolve the question of, is there a jurisdictional conflict between the first and second claimant's claim, the DIFC, and the second claimant's claim in the Dubai court. They refer both of them, and that then triggers the ability to have a stay over both of them.
Well, that raises another nice question, doesn't it? And that is whether, under the terms of the decree, that which is stayed is the proceedings. Where there is a conflict of jurisdiction, it is the whole of the proceedings, even though there might be parties to those proceedings whose claims aren't stayed, or whether, to that extent, the proceedings can continue. So, in other words, I'm putting that poorly, but the question is, in the DIFC courts, is there one proceeding, or can you, for the purpose of the decree, say that there are two proceedings? That is, one being a proceeding in which there is a claim brought by first claimant, another being a proceeding which is a claim brought by the second claimant. It's only if you can say there are in effect two sets of proceedings that there can be a separate stay.
I respectfully say you do see it that way, i.e. that you can say that that the word proceedings, when it's used in the decree, must mean that you have to look at the individual claims which are being made by different claimants, because otherwise you could have a situation where, for instance, you had multiple defendants who had, one of whom had decided to commence a hearing in the onshore courts and then say, well, I have a proceeding on the onshore courts which covers the same subject matter, and therefore the proceedings should be halted. To which some of the other defendants who are unconnected to that defendant may well say, well, no, I don't want that at all. I want this resolved.
But it's rather different when you look at it from a perspective of a defendant, because a claimant can bring proceedings against multiple defendants where the requirements of the rules are satisfied with respect to some common issue arising. So that if it's under the claimant has a joint claim against several defendants, it can be brought, and one can see a situation in which there would be a stay of proceedings against one defendant, but the claim against other defendants could proceed. But it's rather different where the claim is brought by claimants jointly, as is this case. Because when the claim is brought by them jointly, it's very difficult to see, because the requirements for joinder of claims are quite different to the requirements for joinder of defendants.
Yes, but doesn't it go to the same point? I mean, of course I see the point that the requirements for joinder of claimants are different than those of defendants. But it all goes to the interpretation, doesn't it, of what proceedings means in this situation.
Yes.
And the point I'm making is proceedings must involve looking at the claims which have been made between claimants and defendants. And it can't be right that as long as proceedings can't mean a different thing for claimants than it does for defendants.
Well, I think they can, because a claim by let's say a claim by one claimant against several defendants can usually be severed, so that the claim can proceed against some defendants without proceeding against others, and it's not at all uncommon for stays to be granted against one defendant for some reason or another. It's rather different, I think, though, where you sever the claimant's claim. There are very, very few circumstances that I can conceive of in which it'd be appropriate to sever a claim, and certainly not one in which the claim is brought jointly by the claimants under the same policy, and where there is a limit of indemnity to which both are entitled. So in other words, it might come down to the question of severance. And when you're looking at severance, there may well be a material difference between the position of a defendant in a particular case and the position of claimants, at least in a case in which, as in this case, the claim is brought jointly.
So I see the jointly point, but of course, claims brought by claimants are very often severed. I mean, just off the top of my head, I can think of a couple of examples, such as where security for costs is ordered against one particular claimant who's not able to proffer it, and so that claim is stayed whilst other claimants' claims proceed. I mean, that happens. I don't know how frequently, but it's certainly possible. And for what it's worth, I'm aware of at least one case in my career that's exactly what happened, where the other claimant's claims proceeded, but one particular corporate claimant could not proceed because it wasn't prepared to put up security for costs. So it is perfectly possible to sever it. But doesn't it come back to the point of what proceeding means under the decree,
yes,
and whether or not it can be appropriate and sensible to allow a defendant to cherry pick one of the claimants, rely on the fact that it's that claimant that they're going after, and on the back of that turn around and say, well, that automatically means that a stay applies now, not after the JJC has made its decision, but applies now before the decision is made to all claimants. That's the situation we're faced with now, Judge. I'm happy to see the force in all the points of, well, what happens if and when in months' time, in who knows, a number of months' time, the JJC says that one of these claims that the second claimant's claims have to be dealt with in the Dubai court. I can understand that I'm going to be faced with a different situation. I hope it won't decide that. I hope it's going to decide it's the DIFC that deals with it. But at the moment, the sole question before you is, in a situation where the defendant has chosen to refer only one of the claimant's claims to the JJC and prayed that in aid, whenever you look at the respondent it's talking about, does that mean that automatically, where there are two claimants and they're making a joint claim, the other claimant is stymied as well? I say it shouldn't be, because it rewards a defendant for cherry picking in that way. And that's
do you want to address me on the proper construction of the decree in relation to this issue? And if so, which translation of the decree would you like to work on?
I'm just trying to find the decree in the bundle.
I'm not sure that it's there. I may be wrong, but I'm not sure that it's there. the relevant provisions are set out in the decision of the Court of Appeal in Lacan.
Yeah, I'm just pulling that up now, which is at O. Just give me a second to pull that up. I know the decrees from 18 onwards.
So in paragraph 20,
the relevant section is at O5, and it's Article 5.
Yes.
Which says the claims or applications in respect of which there is a dispute as to jurisdiction shall be stayed pending a decision of the Judicial Committee in determining the competent court. There shall be a stay of execution in respect of any conflicting judgments. Now, we haven't got item 2. There isn't conflicting judgments, obviously. There's only one judgment, and that's the DIFC. So the actual words that we need to look at are the claims. The claims are
applications. In the Westlaw translations, it's described as actions or motions subject of the conflict of jurisdiction.
Right. Well,
so that's another complication.
It is. Let me. The only sensible way to deal with it is to deal with it both ways. It may be that there isn't a difference, in fact, in the outcome, but let me deal with it both ways. In terms of the claims or applications, Judge, you can understand how I pray that in aid. It is. It's probably pretty obvious. I'm saying that the second claimant's claim is stayed. By definition, Article 5 is not saying the proceedings as a whole. It is making it absolutely clear that you have to look at the claims or applications. Here, we're not even talking about an application. The real question is, what are the claims that should be stayed? I'll get to the second translation in a second. At best, the outcome should be that the claims made by the second claimant should be stayed, and the claims made by the first claimant should proceed. If the outcome of the JJC is that the claims of the second claimant go off to the Dubai courts, which we hope that will not be the outcome, but if that's the outcome, then we'll have to face that situation when it arises. But that is not the situation that faces us. The situation that faces us is that it is only the claims of the second claimant that have been put forward. The claims of the first claimant that has his own cause of action have not been put to the JJC. Similarly, if I turn to the Westlaw translation that talks about actions or motions, again, motions is in that situation obviously a synonym for applications, and that can fall away. There is no distinction to be made in my respectful submission between the words the claims or the actions in that context. Again, there are two actions here. There's an action by the first claimant and an action by the second claimant.
Well, the contrary view is that there is one action, which is a joint claim by both claimants. And on that view, whichever interpretation you take, if there's one claim being a joint claim by both claims, then or one action being an action brought jointly by both claimants, then it falls within whichever interpretation you like.
So I agree. If that's the view you take, equally it falls within either interpretation. Yeah. I suggest that is not the correct interpretation.
But you need also, I think, to look at Article 4, which refers to a dispute as to jurisdiction between the Dubai courts and the DIFC courts, where either or both courts had claimed or disclaimed jurisdiction, or had issued inconsistent decisions on jurisdiction. So if that countenances a situation in which there would be, as the words were used in Lacan, a conflict between the exercise of the jurisdictions in the two bodies, then that would inform the content of Article 5. So then if the question is, and this is really the question we're coming to, I think, in your submissions, and that is there a conflict in the jurisdictional exercise as between the two courts? And if that conflict arises from the tension between dealing with a joint claim in one court and a singular claim in the other, then that would, I'm putting this poorly, but I think you get the drift. So in other words, if the conflict is between a joint claim and a single claim, then you would construe Article 5 as applying to the claims which give rise to the conflict, not just the claims of the individual parties. Do you understand what I'm trying to put to you, Mr. Branning?
I do, but I'm worried that's a bootstrap argument, in the sense that you have to, I completely accept you have to read both Article 4 and Article 5 together. But Judge, you're taking you're saying, well, Article 5 is dictated by Article 4, and I think what I'm saying is, if you read them both together, one isn't dictated by the other. And in a situation where you have, in fact, two claims that have been made by two claimants, albeit they've made them jointly and to do with the same subject matter, that informs what, in fact, might be a conflict of jurisdiction. Because in order for my learned friend to get home here, he needs to show that there is in fact a conflict of jurisdiction between the two courts, and that he has referred the claim or application which gives rise to that conflict of jurisdiction to the JJC. And it does come down to, I think, and ultimately you're either with me or not on this, it comes down to whether you can say these two claimants have two individual, because separate is a loaded word, have two individual claims or two individual actions that they are making, albeit they are proceeding jointly and it is to do with the same subject matter.
Well, Mr. Branning, sorry, please finish.
Well, no, you obviously have a.
Well,
you're obviously talking about that.
You keep on saying that the defendant has only referred the second claimant's claim to the JJT, and you took me to the application to make good that proposition. But I'm just wondering how that fits into the structure of Articles 4 and 5, because taking the Wilberforce Chambers interpretation to start with, it goes in the Article 4, in the event that there is a dispute as to jurisdiction between the Dubai courts and the DIFC courts, etc., an application for the determination of the competent court or the judgment to be enforced shall be submitted. So it's not a reference of proceedings to the court, it's an application for determination of the competent court. And then once that application is made, then the claims or applications in respect of which there is a dispute as to jurisdiction are stayed. So in other words, one doesn't refer particularly proceedings to a court, one says there is a conflict of jurisdiction, and then Article 5 kicks in. So then the question is, what is the inconsistency or conflict of jurisdiction? And on one view, as I put to you a minute ago, it is a conflict between the joint claim being brought in the DIFC court and the singular claim being brought in the Dubai onshore courts. That's given rise to the conflict in jurisdiction, and so then it's those claims that it should be the subject of the stay. Do you have any comment on that?
Well, I see the point you're making, but what, with respect, it is overlooking is the nature of the application that has been made. The defendant has chosen to make a specific application. That application is one that does not seek to refer the claim which is made by the first claimant, but only the claim made by the second claimant. And so whenever we look at Article 4.1, and it talks about an application for the determination of the competent court, the application which has been in fact made is for the determination of the competent court of the claim made by the second claimant, but not the first. And again, it didn't have to be like that, but it is possible, of course, that if they'd mentioned or included the claim made by the first claimant, it is possible the JJC would have rejected the application and not registered, because they'd have said, well, there's no proceedings going on in the second court by the first claimant. And so, completely taking on board your point that you have to then look carefully at what the application is that has been made. The application that has been made for the determination of the competent court is in relation to the second claimant's claim. The problem with the way you have put it to me, Judge, is that then bootstraps and saying even if a defendant has chosen to restrict his application in that fashion, it enables him to say, well, that also brings in the first claimant, and the first claimant's claim or action should also be stayed. And I'd say it didn't have to be that way. They could have made a different application. They could have made an application for determination of the competent court in relation to both the first and second claimant's claim, but they didn't. I mean, the net result is the first claimant does not have any rights to respond to the committee. So insofar as the first claimant wants to say, well, hold on, why is my claim being stopped, committee? Please take into account my interests. Because the application for the determination of the competent court has been made in the way it has, we have no locus as first claimant to make any of those points. And to say, for instance, well, the reason why you should say it's the DIFC court is because we are a DIFC registered entity, and it'd be completely wrong for you to decide it should be the Dubai court. And underlying all of this is this point. One can see how, in the particular jurisdictions we're talking about, I mean, I'm sitting in England, you're sitting in Australia, but we're actually sitting in Dubai now looking at these two Dubai jurisdictions. One can, of course, see that it is a necessary evil to try and resolve these jurisdictional questions, but it is an evil. The starting point should be that if people are have commenced proceedings in the with the right claim form and paid their fee and it's all in the right format in the DIFC, those proceedings should be allowed to proceed unless there is a decree or something else which makes it appropriate, unusually, to not allow parties commencing matters in the DIFC to get justice in the DIFC.
But one of the reasons for that might be that they previously commenced proceedings in the Dubai onshore courts.
Oh, it may be that the evil in this case is necessary. Right, I'm not shying away from that. But the point is, it is an evil, and you do have to look carefully, as you have done with me this morning, at the underlying legislative provisions to see what they say. And they are making clear that you to look carefully at an application for the determination of the competent court, and on the back of that, stay only. Well, I've added the word only, but the purpose is to stay the claim or the actions, to use the different translation, in respect of which there is a dispute as to jurisdiction, which forms the subject matter of the application.
But in this case, there's a judgment. There's a judgment in favour of both claimants.
Yes, there is.
So you're saying that there should be a stay of the judgment against the second claimant, but not against the first. Yes,
I am, and well, I understand that there are some difficulty with that, but that is the net result of a judgment having been entered. There's no conflict in judgments here. There's only one judgment that's been entered, and it means that only one of the claimants can enforce that judgment and not the second one. That's the effect of the stay. Now, if matters then proceed to the Dubai court, and in the Dubai court, and again we hope they don't, but if that's the outcome of the JJC proceeding and it goes to the Dubai court, and the respective defendants get a judgment going the other way, there will be a conflict in judgment. And then the JJC will have to resolve that.
Well, if the judgment stands in favour of the first claimant, there's nothing left to determine in the Dubai onshore courts, because the rights of the claimants have been fully exhausted by the judgment in favour of the first claimant. So doesn't that give rise to a conflict?
Well, no, because if the judgment is stayed pending the if the judgment in favour of the second defendant is stayed pending the outcome of the JJC.
By the second claimant.
Sorry, I'm not sure what I said, but yes,
yeah.
for the second claimant, it's stayed pending the outcome of the JJC. Well, then goes down the branch tree to work out what happens. The JJC may say, in fact, the DIFC is the correct party to deal with this, at which point there isn't an issue. But if the JJC says that the Dubai courts are the correct party to deal with the second claimant's claim, then that will have to be resolved in the Dubai court. But
there's nothing left to resolve.
Well, there is. There's the liability.
Exhausted.
No, there is. There's the liability of the defendant to the second claimant.
But there can't be any liability, because judgment has been entered in favour of the insurer, in favour of the first claimant for the entire limit of indemnity. So there's nothing left for the second claimant to claim.
Well, there is. The second claimant, what's left for it to claim its entitlement to those monies as well. It doesn't mean the monies have to be paid twice, but it does.
But then you get judgment. You'd get two judgments. You get a judgment in one court in favour of one party, and a judgment in another court in favour of a different party.
And in that situation, yeah,
that can't possibly be right, can it?
But this is exactly what this is exactly one of the two circumstances or situations that the JJC is set up in this jurisdiction to deal with. It expressly envisages that you may have differing judgments in two courts, and the JJC then work out which of those judgments shall that
But that, with respect, I think that misses my point. Correct me if I'm wrong. But my point is that as long as the judgment in favour of the first claimant stands, then that exhausts the second claimant's rights. So the second claimant has nothing to enforce in the Dubai onshore courts.
No,
and if that's right, and that's because the claim has brought them jointly. And so under the scenario you posit, there could be a judgment in favour of the first claimant in this court, and then the second claimant could proceed in the Dubai courts and get judgment for another 25 million dirham against the same defendant. There'd be two judgments out there. You shake your head. Well, what then would happen in the Dubai courts?
What would happen? Well, one of two things would happen. Either there'd be, and again, just looking at each of the possibilities, either it would be decided that, sorry, let me go back a step. The second claimant would be entitled to its judgment that it too was entitled to recover under the policy, but it would not be able to enforce the money if it had already been paid for 25 million. It would be entitled to its declaration that it was entitled to cover under the policy and entitled to the proceed to the policy limit, but it obviously would not be able to recover. It would have to give credit for the fact that that sum had already been paid out under the policy. That doesn't mean it wouldn't be entitled to judgment for a declaration that it was entitled to make that recovery under the policy. It would merely mean it would not be able to enforce it because the sum had already been paid.
Well, all right. Well, the contrary view that I put to you is that if the judgment remains in favour of the first claimant, that exhausts the rights of all insured, and there's nothing left to claim. But you say no, there would be something left to claim. It could claim declaratory relief, but not monetary relief.
Yes, and it must be because it has its own separate insurable interest under the policy, and it may it's possible to devise scenarios in which it's in the second claimant's interest to continue to get that declaratory relief to show that it too was entitled to that money. I mean, there may be all sorts of tax reasons why that might be a sensible thing for it to do. There may be all sorts of reasons for why that's an appropriate thing for it to do. But theoretically, it must be entitled to continue and get its declaratory relief, albeit if the money has already been paid, it would not be able to recover the same money that has already been paid out under the policy.
Yes.
Judge, I'm very conscious we've spent virtually all of our time on.
Well, that's my fault, Mr. Brannigan. So
No. It's not. It's always far better to understand what the court's thinking so that you can address it rather than the court think slack and not address it. To some extent, we've dealt with point 2 as we've done on. I think there is a conflict here in a situation where all that has happened in the Dubai court is that the parties have put in pleadings. The pleading from the defendant in each court has asked for the matter to be stayed. And in both
sorry, I haven't seen the pleadings in the Dubai courts, but it's common ground, is it, that pleadings have been put on? So yes, that in the Dubai, okay, thank you.
Yeah. In my skeleton, I think I've made reference. You can go after the hearing if you think it's appropriate to do so, to look at the pleading which has been put in by the other side. But in effect, the pleading by the other side denied the claim and asked for the claim to be stayed on the basis that there had been a reference to the JJC. And the Dubai court in both instances have said, well, if there's been a reference to the JJC and proceedings have been filed in both courts, then a stay should be ordered, and that is what they have done.
All right, but there's to summarise it then, the proceedings have continued in the ordinary way. There's been no objection to jurisdiction by any party, and there has been a stay because of the reference to the JJT.
That's right. But there has
so
been
why is, in Lacan terms, why isn't that the exercise of jurisdiction by the Dubai onshore courts?
Because by definition, what the Dubai onshore courts have said is there's been a reference to the JJC, so we're not deciding on jurisdiction.
But there's been there has been no application to contest jurisdiction, so there will never be an occasion for the Dubai court to question its jurisdiction, and it's exercised the jurisdiction by enabling the proceedings to continue with pleadings being filed.
Well, if that's the view you take, then you're against me on this. The point I was making is that simply allowing pleadings to run is not a sufficient step for the purposes of Lacan, because the court was neither expressing or decrying its jurisdiction.
Well, all right, that's the argument. But Lacan was a very special case and very different from this. Very different from this because in this case it's your clients who've instituted both sets of proceedings, which is pretty unusual in itself. But the essence of Lacan, as one who was in the case, was that it was unusual in the sense that all that had happened in the DIFC courts was that there had been an objection to jurisdiction. So the question was whether, the old competenza court itself deciding whether it had jurisdiction gave rise to a conflict of jurisdiction. And the answer the Court of Appeal gave was that no, it didn't. Now, if in this case, I can see how that principle would apply in this case if there hadn't been a default judgment in the DIFC courts. So that if all that had happened is that you'd commenced proceedings in the DIFC courts, no judgment had been entered, and then the defendants had lodged an objection to jurisdiction in the DIFC courts, then I can see the parallel with Lacan, because there would then be a situation in which the DIFC there was an extant objection to jurisdiction, and the DIFC courts had not determined whether or not to exercise jurisdiction. But in this case, your clients moved for and obtained default judgment. and there's no more dramatic exercise of jurisdiction than the entry of judgment. So you've got the exercise of jurisdiction in the DIFC courts. So the question, I think, turns upon the question we've just discussed, and that is the receipt of pleadings in a situation in which no objection to jurisdiction has been brought, is that the exercise of conflicting jurisdiction? And if it is, then you, subject to the point you've made about the first claimant succeeding, then your application fails, at least in relation to the second claimant, doesn't it?
Yes, that's correct, and you have correctly summarised it. I, of course, accept that there has been an exercise of jurisdiction by the DIFC.
Yes.
Plainly there has been. And it does turn on whether in the court accepting the claim form in the onshore courts, pleadings being exchanged, and then no steps being taken by the court save for staying the proceedings once the because the JJC application has been made, whether the mere receipt of pleadings by the court in that case amounts to an exercise of jurisdiction. We say it doesn't. We say that it is simply the case running without there being any exercise by jurisdiction by the court. And we say that, and I've set out the relevant extracts from the judgments of the court below whenever it was asked to stay this. We say that it's clear that the court below is in effect saying, well, because a claim has been filed in these courts, that gives rise to a jurisdictional conflict. The court is not suggesting that it has made any decision of its own about jurisdiction. And it's not even saying it's exercised jurisdiction. It is saying a claim has been filed in this court, an application has been made to the JJC, and that's enough to give rise to a stay, which is obviously, in a way, the opposite to Lacan, which was saying that a court had to actually exercise its jurisdiction in some way. So it does come down to whether simply the fact that the parties have put forward pleadings or exchanged pleadings in the Dubai court amounts to the Dubai court exercising its jurisdiction. We say
and critically, I think the lack of any objection to jurisdiction.
Well, we did not make objection to jurisdiction.
No, you didn't. You invoked the jurisdiction, but the point is the defendant didn't make any objection to jurisdiction, so no occasion for a jurisdictional issue being determined will arise.
Yes, that is not fatal to the question of whether or not the court has in fact exercised its jurisdiction.
Yes, I understand.
So, Judge, I'm obviously very happy to answer any other questions you have, but I think you've got the thrust of my submissions. Sorry, I think you may be on mute, Judge.
Right, I keep on doing that all the time, I'm afraid. You'd think after 18 months I would have got the hang of it, but not, apparently not. Well, we've been going for an hour and 20 minutes. Gentlemen, would you like to take a break now, or do you want to, Mr. Jones, would you like to make a start first, or should we take a 10-minute break now, say?
Look, Judge, I think that probably is very sensible.
Right,
just,
right.
Just, not so much to not interrupt my flow, but just so that everyone's sort of fresh and ready for the next stage.
Yes, good. All right, is that convenient to you, Mr. Brannigan?
Absolutely.
Must be very early in the morning for you, so, Mr. Brannigan. So
it's 6 a.m. We started at 6 a.m.
Right.
So
well, you probably need some caffeine.
Oh, I've had plenty of that. I wouldn't worry. I just need to top it up, not so much caffeine.
All right. Well, we'll take a 10-minute break then, if that's convenient. Just leave the screen on, but just go on, turn off video, and go on to mute, and we'll resume at 1/2 the hour wherever you are.
Okay. Thank you very much.
Very grateful.
Thanks. Reassemble. Mr. Jones, is it convenient for you to start?
Yeah. Just before
Just
before Mr. Jones start, my usual practice in these remote hearings, so as not to distract anybody, is to turn off my camera whenever I'm not speaking. So if you're happy with that, Judge, and don't think it's disrespectful,
Yes.
that's what I'll do.
No, certainly, Mr. Brannigan. It's fine.
Thank you.
I'm grateful, Judge, and I should say I note that I had my camera on all the way through Mr. Brannigan's submissions. I hope that wasn't distracting.
Not to me, anyway.
Well, you're the one who counts. Judge, if it's acceptable to you, I propose to deal with this by addressing 4 points. The first is the question of whether a referral of the first claimants in each proceedings claims needed to be expressly made to the JJT, which has been a point that my learned friend has developed at some length. The second point is what the motivation on the part of the claimants for bringing these parallel proceedings is, and what the relevance of that might be. The third point is whether the Laken and Lamia authority is strictly on point to a situation such as this. What I'll be saying in that second point is we need to read that authority mindful of the mischief it's seeking to deal with. And the fourth point is, assuming that the Laken and Lamia authority does foursquare deal with our situation, what does the guidance say about the situation we're in? So if that's acceptable, Judge,
Certainly, Mr. Jones, please proceed. That'll be helpful.
I'll proceed in that matter. So first, to tackle head on what has been the key charge against us, it has been said by my learned friend that essentially the defendants have brought this on themselves by making an application to the JJT, which explicitly refers, or almost exclusively explicitly refers to the respective second claimants' claims. So those are the operating companies of the hotels, and only in passing refers to the first claimant, the holding company, and doesn't expressly refer that party to the JJT. Now, what I say is that what's been done is entirely appropriate, because that's all that is necessary for a referral to the JJT. And perhaps I can just take the court back to the decree wording. I've been able to find the actual decree in the bundle rather than just the quotation.
Oh, good. Good, well done. Where do I find that, Mr. Jones?
So it begins, Judge, on page E94, which is in the exhibit to Mr. Wayne Jones's witness statement.
Yes, thank you.
And the relevant sections, Articles 4 and 5, are at E95 and E96.
Yes, thank you. And this is the Lexis.
Yes, this is the LexisNexis translation. Yes. I think I'm right in saying that's the same thing as the Westlaw translation.
Yes, I think that's right.
I'm afraid, for my purposes, I'll still need to look in the Laken and Lamia quotation for the Wilberforce Chambers translation.
Yes.
But frankly, I don't think it makes any difference.
Yes. No.
And so the point is, the point is one that's already been raised by you, Judge. Namely, what is this decree actually referring to? It's referring to the staying of claims. If we look at Article 5 on page E96, the effect of the referral is discontinuation of the proceedings in the cases or claims on which a conflict of jurisdiction has arisen pending a decision. So the situation is that the cases or claims are put on ice pending the decision. The other translation, as we've heard, says that actions or motions are stayed pending a decision. Now, all of these translations, in my submission, are dealing with words of general effect rather than specific formalistic technical words.
Well, I think some of the other interpretations don't refer to proceedings; they refer to claims or applications. So I think there's at least three alternatives. One is proceedings, the other is claims or applications, and the other is actions or motions.
Indeed.
And your point is that generically they're all the same.
But more than that, because of the use of such a catch-all, clearly what the decree is intended to cover is all types of legal proceedings. And what we say is that it was only necessary to make the referral to the JJT in the manner that it was done. And that's because not just of a broad reading of what the decree says that its effect is, namely the staying of the claims, but when you look at the claims that have actually been brought in the DIFC court, those claims are not, as my learned friend has sometimes sought to characterize them, separate but duplicative claims by separate parties, but rather a joint claim jointly brought by two entities. So if we go back to the claim form in case 27/2021, and that's in the bundle, it starts at C1.
Yes.
If I could take you, Judge, to page C9, which of course is the gravamen. It sets out what the basis is, but this is what is sought. The claimants, that's a joint term, request the court to grant the following relief: to pay the amount, so that's a single amount, in favour of the claimants. We don't have, as has sometimes been characterised, we don't have different claims from the two claimants saying that on the correct construction of the policy, each of them are entitled to the full indemnity limit, and that therefore you could have theoretically a situation of one claimant getting a declaration of its entitlement even if the other claimant had received the full judgment. Never arise, because that's never been asked for in the DIFC court. What's been asked for is the claimants as a team seeking a single remedy. And because that is what has been asked for, it must follow that when you stay the claim as it is brought by the second claimant, you are automatically staying it for the purposes of the first claimant as well. And if that's right, it means that referring the second claimant's claim to the JJT is also necessarily a referral of the interest of the first claimant to the JJT. And perhaps I could just make good my submission that there's absolutely no suggestion of a divisible claim in these particulars of claim, because there is in the pages C2 to C8, or rather C9, where the details of the claims are set out, there is no separate reference at any point to the first claimant having its own entitlement under the policy. There's no suggestion that, for instance, the policy has a insuring clause which only a holding company can take advantage of. Quite to the contrary, on a number of occasions, the only entity that's referred to is the second claimant, the operating company. And that's from the defendant's point of view, totally unsurprising, since it's the defendant's case that only the operating company could be entitled under a policy. But if we look, for instance, at point 9 of the particulars of claim, which is at the turn of the page C3 to C4, what is said as one of the things that has been caused and one of the losses is decontamination and cleanup of one of the insured properties, namely 5 JVC Hotel. It's not suggested that there are separate costs incurred by the separate claimants in respect of that. And the whole gravamen of the particulars of claim is that loss has been suffered at the hotel, and that's what is being claimed. Now, it is an argument, a legal argument for a separate forum as to whether under the policy, the holding company is entitled to have an action parasitic on the operating company's claim. But the point is that it has never been expressed before this court that 2 separate claimants bring 2 different claims, which could entitle them to 2 different types of relief, even declaratory relief, such that the stay of one of the claimant's interests could be decoupled from the stay of the others. And so that's why, as a matter of, in my submission, correct legal analysis, the reference of the claim to the JJT, it is correct in its form, and it only needed to expressly say that the second claimant's claim was being referred, because by doing so, it's referring to the first claimant's claim as well, because it's the same claim. So that's analysis and construction. But if we step back and just ask, in terms of practicalities, what is it that the alternative suggestion would lead to? If my learned friend is right, and the correct way for this to spool itself forward is for the second claimant's claim to be considered by the JJT and then either progress in Dubai or progress in the DIFC court as the JJT determines, but the first claimant's claim to progress in the DIFC in any event, that raises the obvious risk of 2 courts being required to make findings of fact on exactly the same policy terms, not just the same policy being considered in different cases, which might be annoying, but it is not an insuperable problem, but the determination of the actual entitlement of this entity, the actual entitlement of indemnity for this loss being considered, and factual findings made by 2 different courts in respect of that issue. And then, of course, 2 different courts applying the tests of, for instance, proximate causation, perhaps applying the new guidance from the UK Supreme Court to how proximate causation works in a diffuse pandemic context.
Mr. Jones, I'm sorry to interrupt, I don't want to put words in your mouth, but is this really, are you really putting the case 2 ways? The first is that on the proper construction of the decree, the, however you describe it, proceedings, action or motion, claim or applications, encompasses the joint claim, and therefore it's that which has to be stayed. That's your first argument. The second argument that I think you might be heading to, and I just want to see if I've got this right, second argument is that if the first argument fails, and it is only the second claimant's claim that should be stayed, then there is an independent basis for a stay of the first claimant's claim not arising under the decree, being a stay in the interests of justice to avoid inconsistent verdicts. Is that how you're putting it?
Yes, frankly.
Okay. Well, I am putting words in your mouth, but
I'm grateful because that is, frankly, if my learned friend's solution to the problem is that there should be two sets of proceedings on identical subject matter, I say that's no solution. And yes. I say, and it's not my application, Judge, which is why we haven't necessarily set out chapter and verse all the different grounds on which the stay should be granted. But the point is, this court, in its wisdom, has granted the stay, recognising that a pause needs to be placed on proceedings until the JJT can come to its conclusion. If the automatic effect of the JJT's procedure, to which this court has traditionally given effect, doesn't give me the answer I need, then this court's jurisdiction to prevent an abusive process and, as you say, in the interest of justice, stop the completely unworkable solution that my learned friend seems to want. I say that has to be the correct basis to continue the stay in the alternative.
Yes, all right, thank you. I understand.
Well, I'm grateful. That probably brings me on to the second issue that I wanted to address, which is what the motivation from the claimant's side was for these parallel proceedings, and what the relevance of that motivation might be. Now, when asked this morning by you, Judge, my learned friend candidly said he didn't know what the motivation was. Now, the claimants have been given the opportunity to explain themselves. And perhaps I could just to make that good, perhaps I could refer to the witness statement of my instructing solicitor, Mr. Wayne Jones. So it's page E54.
Yes.
That's the pinpoint citation, but just for form, I'll take you to the start of the statement, which is at E50, so that you can see what the document is. And then at E54, at paragraph 9, Mr. Jones, fair and square, says, I note that there's been no explanation of what the reason is for the duplicate of proceedings. The court might take the view that it's just essentially a procedural trial by the claimants. Now, there was a responsive witness statement put in by Mr. Kabir Mulchandani. That's at pages E97 to E104. And despite that challenge being laid down by Mr. Jones, absolutely no explanation from the claimants. No explanation was offered in my learned friend's skeleton argument. My learned friend, doubtless doing the best he can, guessed that the possible explanation was that the claimants wanted to be in the best position they could be if there was a challenge to jurisdiction. Now, if that is the explanation, and we must take it with some caution because it's just been offered as a possibility. If that is the explanation, I say it's not a good explanation because that's precisely the sort of abusive use of parallel proceedings that this court should decry. And of course, as things have turned out, the possibility that the defendants would object to the jurisdiction of the Dubai courts hasn't come about. The defendants embrace the jurisdiction of the Dubai courts. They say that's the proper forum. And so in circumstances where proceedings were brought by the claimants in the Dubai courts first, I say it is not an acceptable motivation for the claimants prior to hearing whether the defendants accept that jurisdiction or not to launch separate proceedings, apparently in the hope that they have a fallback if the Dubai court's proceedings are objected to. I say that's a waste of this court's time to be treated as a fallback if the Dubai court's proceedings are objected to. But it also doesn't make sense because they don't know whether Dubai court's proceedings have been objected to. And indeed, it should have been obvious from the outset, we say from the obvious terms of the policy, but also from correspondence, that the Dubai courts would be acceptable, because that's always the situation that the defendants have argued for. Now, my learned friend's solution to this problem of the claimant's own making is to say, well, having set two horses running, he wants to shoot one of the horses and just keep the DIFC court proceedings going. Well, to extend the equine analogy, he's trying to shoot the horse after the horse has bolted. The point is that the Dubai court proceedings, my learned friend is saying, now we are making an election. We want to drop the Dubai court proceedings, but they've lost the ability to make that election, Judge, because we've accepted jurisdiction in the Dubai court proceeding. And that's why the Dubai court hasn't allowed them to be withdrawn. The Dubai court has said, well, there's been a defence put in, and there's also an application to the JJT. We're not going to allow them to be withdrawn. The sticky situation was created or set running by what the claimants did. It does not lie in the claimant's mouth to say now that the defendants need to do them a favour to allow them to get out of that sticky situation. Especially when what the defendants have done in the Dubai court proceedings is not some procedural jiggery-pokery. The defendants have fronted up in the Dubai court proceedings, put in a defence, said this is the right forum, let's get on with it. And in those circumstances, if the motivation, and I say if because we don't know what the motivation was, but if the motivation was to launch both sets of proceedings as some prophylactic against the defendants objecting to the Dubai courts, I say that's an improper motivation. Second, it's a motivation which flies in the face of what the defendants were always going to do in the Dubai courts, namely accept jurisdiction and defend. And that's borne out by what they have done in the Dubai courts. So it was an improper motivation that was a strategic error, and the claimants shouldn't be able to argue that motivation in aid of what they're seeking to do now. And perhaps that takes me to the third submission that I want to make. And this, Judge, is really where I get back into the points that are expressly made in my skeleton argument about Lacan, and also about about Lacan and its applicability per se, and then about the application of the guidance given by the DIFC Court of Appeal in that. But unless you have sort of broader points on the issues that have already been canvassed, perhaps I can go straight to that.
Yes, please, Mr. Jones.
I'm grateful. So I'm now at paragraph 20 and following of my skeleton argument, just for your note.
Yes.
The point is, my headline submission is that Lacan and Lamia, unsurprisingly, is a decision which is motivated to prevent abuse of process. It must be read in that light, and it must therefore be read in a way which takes account of the particular factual matrix of that case, and which does not seek to map the decision across to all cases which don't share that factual matrix. And this is where, if I might say, without being sort of too sycophantic, your intervention, Judge, saying that sort of isn't there an abusive process, it is relevant. It's not a distraction, because of course abusive process is what Lacan and Lamier is about. And so the Lacan and Lamier guidance and the stay enforced by this court pursuant to that guidance is about remedying abusive process. So if this court finds that there's abusive process, but thinks that Lacan and Lamier isn't quite on point, the solution shouldn't be to say, well, we'll let the abuse go because that case doesn't deal with it. No, that case does deal with it. It says we should always deal with abuse, and this is how we're dealing with abuse in this situation. So just briefly, the fact situation in Lacan and Lamier was that the claims in the respective courts, the Dubai courts and the DIFC courts, were brought by separate parties. That's expressly set out in the claim. Lamier.
If it helps, I can still remember the case, Mr.
Well,
Jones. So it was a case in which, to cut to the chase, it was a case in which the proceedings were swimming along in the Dubai court. The point had been reached where the defendant was at risk of a judgment. It then brought proceedings in the DIFC court seeking a declaration with respect to an arbitration agreement. There was an objection to the jurisdiction of the DIFC court. Before that objection jurisdiction was even brought before the court, the defendant in the Dubai court sent it off to the JJT and asked for a stay, and got a stay. And so I understand the point you're making. There was, on the facts of that case, an inference available, although we didn't actually draw it. It wasn't necessary for us to draw that inference in the judgment. There was an inference to the effect that the DIFC proceedings were brought for the purpose of deferring the risk of a judgment being entered in Dubai.
Precisely, Judge. And whether one uses the epithet opportunistic or adventitious or whatever, it was clearly a situation in which, in the face of an adverse judgment, proceedings were initiated and an application was brought on the back of the initiation of the proceedings without anything further having happened. Exactly. It was immediate. And so, and I also make the point in my skeleton argument, perhaps just for your note, that Lacan and Lamier refers to very similar sequence of events in two other cases, Tabarak and Arloyd. That's at paragraphs 47 and 48 of the Lacan judgment. So in my submission, it's totally understandable that the DIFC Court of Appeal was concerned in Lacan to ensure that the procedure of JJT applications should not become some automatic means for parties who are facing adverse judgments in one system to frustrate or delay proceedings simply by putting in the administrative step of issuing a claim in another court. And so that's the type of abuse which Lacan is trying to deal with. The abuse is the opportunistic use of the court system, and particularly the opportunistic use of an automatic issue of a claim form and then an automatic request for a stay from the tribunal, which the Court of Appeal wanted to stamp out. But of course, that's not the situation in the present case. And of course, the court already has the point. Here, the defendants are not responding to adverse outcomes in one jurisdiction by launching spurious litigation in another jurisdiction backed up by a JJT application. Either of the proceedings were brought by the defendants. The defendants have been on the receiving end of two sets of identical, substantively identical proceedings. And so it's not the motivation for the application to the JJT is not an attempt to raise fresh proceedings as a smokescreen to delay things, but rather to seek clarity as to what case they have to answer when the claimants are the ones who filed parallel and duplicative claims. And what the defendants submit is that that is precisely what the JJT system is designed for. When it is unclear what set of proceedings are the proceedings to engage with, you make an application to the JJT to get a definitive answer. Because, of course, under Article 7 of the decree, the determinations by the JJT are binding. So you get a definitive answer, and you can invest your efforts in defending or progressing the correct set of proceedings, rather than everything moves along in duplication and then you have to unpick the problems later. And so what I say is that if Lacan is about preventing abusive use of the two court systems process, and it is, then that same motivation has to inform this court's approach to stay, even if we might say that the terminology in Lacan dealing with judgments and conflicts of jurisdiction and the exercise of jurisdiction by a court, because of course those were the things that were in issue in that case, even if that terminology doesn't quite map to the situation here, we say the motivation of the Court of Appeal in Lacan is clear, and the same motivation makes it clear what the answer in this case is, which is allow the stay to continue in the DIFC court, allow the JJT tribunal proceedings to come to an answer, and then allow the right set of proceedings to get going and the wrong set of proceedings to fall away. But even if the court is against it in respect of that general proposition that essentially we need to be cautious in mapping the precise terminology of Lacan to this case because of the different fact pattern. I say I still win because properly understood, the terminology in Lacan applies foursquare to our situation, and it produces a completely obvious answer. And so that's going to be my fourth submission.
Yes.
Unless there's anything in particular you'd like me to work with in Lacan.
No, that's fine.
I'm grateful. So, looking at Lacan, and both parties have set out the relevant paragraphs in their Scotland argument. The gravamen of the case is that what needs to happen, well, first, what the case says is that either the conflict can arise in a situation of conflicting judgments. Now, we don't actually have a situation of conflicting judgments in this situation. But of course, as the court has already observed, the issuing of a judgment is a positive act asserting jurisdiction over a dispute. So while we don't have conflicting judgments, we do have a judgment, namely the judgment in the DIFC court. Now, we have to set aside for an instant the fact that the defendants object strenuously to that judgment on various bases. But the fact is, it is there. If they could have already set it aside, we'd never be in this situation. But the DIFC court judgment is there. That must surmount the threshold of being a positive act asserting.
Well, I think Mr. Brannigan concedes that.
Indeed.
So, and that being so, the only question is whether the Dubai courts have done anything that gives rise to a conflict of jurisdiction, and I think that's a short point. He says that all they've done is receive pleadings and grant a stay, and that's not enough to be taking a step in the exercise of jurisdiction. The contrary argument is that the court has embarked upon jurisdiction by the exercise of jurisdiction by receiving those pleadings. There is no objection to jurisdiction has been taken and can't now be taken because you've submitted to the jurisdiction by filing your pleadings, and the exercise and the grant of the stay, refusing the application for withdrawal, is itself an exercise in jurisdiction. That's really the battle. Have I missed anything? That's your argument, isn't it?
It is almost exactly my argument, Judge. But the point that I just want to emphasize is that, of course, the language of exercise of jurisdiction comes from Lacan because the issue is whether the court had yet made its decision. But of course, as you've already identified, in the Dubai court proceedings here, that situation has never arisen and will never arise until the point of judgment, because the Dubai courts are proceeding on the basis, as is totally normal, that jurisdiction is primarily something which arises by consent of the parties. Normally, in court proceedings, the court is never explicitly asked to rule on jurisdiction. It is an implicit decision, or an implicit or constructive analysis that jurisdiction has arisen, the court has been seized. And that can either happen because the court is actually asked the question and makes a reasoned determination, or, and I say this is much more normal, and in fact is what is happening in the Dubai courts, it arises because one party commences proceedings and asks the court to exercise jurisdiction, and the other party engages with those proceedings substantively by putting in a defence and getting on with it. And in paragraph 35 of Lacan, it explicitly recognises that when a party commences proceedings, it asks the court to exercise jurisdiction. Well, tick, that's happened here because the relevant operating companies have asked the Dubai courts to exercise jurisdiction. So that's one half of the question of whether jurisdiction has arisen. Then in Lacan, of course, it says that if the court has not made a decision on jurisdiction, then that decision can't be relied upon as giving rise to a conflict. But what Lacan does not say, because it does not deal with it, is what happens when the defendant accepts jurisdiction. Does jurisdiction arise or not? Now, for my learned friend to be right, and for my learned friend to say that there is no conflict of jurisdiction until the court has been asked explicitly to rule on jurisdiction and has decided upon it, what my learned friend must also be saying is that in every case, prior to judgment, the court cannot be said to be seized of the dispute because it has not been asked that question. And that just can't be right. The court is seized of the dispute where the parties refer the dispute to it and don't object to jurisdiction. That's how jurisdiction by consent works. Lacan is dealing with the unusual situation where a court has been expressly asked to determine jurisdiction, and as a matter of chronology, has not got around to do it yet. And what the Court of Appeal of this jurisdiction is saying in Lacan is, in those circumstances, essentially, you can't presume the answer. You can't presume the answer and then on the basis of that presumption, go to the JJT and say, look, there's a conflict of jurisdiction, please stay the proceedings. Because that is stripping the DIFC court of its decision-making. If the question, is there jurisdiction, is still up in the air, you can't say that it's been determined and on the back of that determination, go to the JJT. But I say the situation in this case is very different. The question of jurisdiction is not still in the air. It has been asserted by the operating companies by bringing the claims in Dubai. I say parenthetically, apparently they regret that, but so what? It has been accepted by the defendants in defending those proceedings. It's not been, I should add, it's not been accepted opportunistically or with some malafide. The defendants genuinely think the Dubai courts are the right court. And that's why they're contesting the DIFC jurisdiction in their acknowledgement of service, because they say that the insurance policy doesn't provide for DIFC jurisdiction. So from the defendant side, it's very clear. These claims should have been brought in the Dubai courts. Happily, they were. They are being defended in the Dubai courts. But unfortunately, there is a separate assertion of jurisdiction by the DIFC, thanks to the default judgment. And as a result, there is a conflict of jurisdiction.
Well, I think if you go to paragraph 37 of Lacan, Mr. Jones, I think the matter was expressly left open by the court there because it said it's unnecessary to decide in this case whether the step must be a decision on jurisdiction. Now, that's Mr. Brannigan's point, I think, that it has to be a positive decision that we have jurisdiction, or whether it suffices that the court exercises jurisdiction towards determining the claim. Then goes on to explain the reason for that was because that question didn't arise on the facts of that case, because the only thing that had ever been done was to entertain an objection to jurisdiction. And on any view, that couldn't amount to a conflict in jurisdiction. So the question you're now posing is the question that was left open in Lacan, and that is it sufficient if the ordinary court process proceeds, there is no objection to jurisdiction, and then in accordance with common law principles, it'd be, or probably more correctly, private international law principles, there would be no capacity to object to jurisdiction once you've submitted to it. In that circumstance, does that give rise to a conflict? And your answer is yes, it does.
Exactly, and I want to distinguish the situation that I'm talking about from the, I think, extreme situation that my learned friend referred to. He was saying that it can't be right that jurisdiction arises from a court simply accepting a claim form. You know, the electronic filing system just receiving a PDF claim form, mere receipt of pleadings is not enough. And that's probably right, that you can't get jurisdiction simply by sticking in the claim form. And obviously, if you could, the issue in Lacan would never arise because the claim form had been put in. But what my learned friend does not go on to, or what my learned friend's extreme example does not address, is the situation we have here, which is where a set of pleadings have been put in by a claimant, and they've been responded to substantively by the defendant in a manner which is only consistent with an acceptance of jurisdiction.
Yeah, well, you've submitted to the jurisdiction.
Exactly, we've submitted to the jurisdiction.
So therefore, the court has jurisdiction, and is proceeding to exercise it by receiving your pleadings, and has now exercised it by refusing the application for withdrawal and by granting a stay.
Exactly, and that's the next step, of course, because it could be that at that opportunity to sort of grasp the nettle and look at the case, the court could have made some determination or something like that. But the point is, my chief point is that it's a matter of consent, and that the parties have given rise to jurisdiction via consent. But of course, the backup is off the back of that consent, as is completely unsurprising. The court has progressed with the claim as though it is a claim properly brought to the Dubai court by saying, first, it cannot be withdrawn because a proper defendant objects to its withdrawal, and because it is a claim in the Dubai courts and there's another claim out there in the DIFC, there needs to be a stay because there's been a referral. And so I say all of that is consistent with there being, all of that is consistent with the threshold in Lacan and Lamia being met. And the threshold is not, has there been a positive determination in a judgment on the question of a dispute of jurisdiction? Obviously, that would be a nice explicit example of the court exercising jurisdiction. But the threshold is, has jurisdiction arisen in the case, whether by court decision or, as is much more common, by submission to the jurisdiction? And I say it has. And so that's a relevant exercise of jurisdiction, albeit not an exercise by the court itself. But it's precisely the sort of positive step that the Court of Appeal was looking for in Lacan, and in fact has happened in this case. And so in those circumstances, bringing the threads together, I say that the question that has recently been raised by the claimants of whether there could possibly be a situation that has the second claimant's claim stay, but the first claimant's claim proceed in the DIFC. So as to that question, I say that's a question which is purely theoretical. And when you analyse the claims that are brought in the DIFC, it doesn't arise because it's the same claim brought by both claimants jointly, rather than two claims that happen to be both set out on the claim form. And so the same claim has been referred to the JJT. The JJT has stayed proceedings. The approach of this court, the DIFC court, as set out in Latham and as dictated by this court's jurisdiction to prevent abuses of process, is that a stay is the only appropriate mechanism to ensure that justice is done. Happily, a stay has already been ordered very sensibly by His Excellency Justice Al-Mahari, and this court is in the position where it can simply let that stay continue. Nothing that's been said by my learned friend renders the continuation of that stay an abuse of process. Nothing that's been said indicates that a conflict of jurisdiction in the terms that Lacan properly understood means has not risen, such that the application of the JJT was wrong. And nothing has been suggested as sort of some practical workaround that allows for the claims to go ahead in the absence of a stay. The practicalities are all on our side, and I say the technicalities are all on our side as well. And Mr. Brannigan's attempt to come up with a technical argument to reheat the DIFC claim, and then, as he frankly admits, perhaps have to deal with catastrophic practical difficulties later, is, in my submission, not a good argument. So those are my submissions. Thanks to a lot of clarity from the court, I think I probably got through them a little quicker than I initially anticipated. But if I can be of any assistance, I'm happy to be.
No, Mr. Jones, I think through the assistance of counsel, the conflicting arguments have been well identified. So thank you. And of course, I'll give unless there's anything else, Mr. Jones, I'll now give Mr. Brannigan the opportunity to reply.
I don't think so. I'm looking hopefully at emails to see if I'm getting any last-minute instructions, yes. But I don't think I am.
Where are you, Mr. Jones? Are you in the Middle East or are you in England as well?
I'm in London.
Oh, right. So very early start for you too.
An early start, although originally a Sydney-sider.
Right. Yes. Well, I gather that I could see the Aboriginal art in the background, so I thought I don't know whether I hope that wasn't put there for my benefit.
No, not at all, Jack.
All right. All right. Thank you, Mr. Jones. Mr. Brannigan.
Thank you.
That's where I've gone wrong. My art is always terrible. What I should have is a revolving sequence of pictures. I should research my judges and then try and find the one that works. So you're on mute.
These days, Mr. Brannigan, if you had a live screen there, you could easily do that.
Easily do it.
Yeah.
This is. I'm going to look into that. I often find that submissions don't get better by simply repeating what I said before. So I'm going to just make 4 short points just in response to my friend's submissions. The first one's about this abuse of process point. I don't mean a brickbat when I say my learned friend's jumping on that bandwagon. I've jumped on plenty of bandwagons in my time as the court has rolled them past me. But that's not the bait. I mean, that's new, and it's not a good point for this reason. One could see the abusive process point if we were maintaining both horses, but we are not maintaining both horses. The only reason why the Dubai court proceedings were stayed and not disposed of is because the defendants insisted that they continue. We have not only made our election, but made it in the most concrete way possible by positively saying we wish to withdraw those proceedings.
But the problem with that, though, Mr. Brannigan, is let's say the defendant takes the position, which Mr. Jones tells me it does, that the Dubai court is the proper court. Now, you commence proceedings in that court. The defendant says, fine, that's the right court. Here's our defence. And then you say, well, now we want to withdraw because we've got these proceedings going in the DIFC. Now, you can hardly blame the defendant then for saying, well, no, we're not going to let you withdraw, because if you do and go off to the DIFC and then get thrown out of the and our objection to jurisdiction of the DIFC court is upheld, then you'll have to come back here anyway if you want to pursue your claim. So why should we go through that process? So in other words, this is a long-winded and ineloquent way of saying that perhaps you're the author of your own injury in that regard by commencing the proceedings in the first place.
Well, I understand the author of her own injury point, but it's a different point than abuse of process. If the court is sitting now and thinking to itself, well, we have to avoid a situation where the claimant is attempting to or is abusing the process of both courts, the answer is, well, the claimant is absolutely not doing that.
Well, Mr. Brannigan, if it helps, I'm not presently minded to resolve this case on the basis of the type of abusive process that I enunciated in the course of argument, because I accept that issue hasn't been fully joined on the skeletons on that topic. But I should warn you that what I am considering still is the point I put to you and which was embraced by Mr. Jones, and that is in respect of your point about the first claimant. What I am putting is, what I am considering, out of fairness to you, is the possibility that if I were to find in favour of your submission that the decree doesn't enable a stay of the claim brought by the first claimant, then the nature of the relationship between the claims brought by the first and second claimants is such that a stay of the claim brought, insofar as it's brought by the first claimant, could be justified on broader interests of justice grounds.
Well, let me deal with that directly then.
Yes.
The issue there is one of timing, and it's a timing. That issue goes thus: if the court were to take the view that that is going to exercise its wider discretion in that way, if I put it like that,
yes,
then the difficulty is that it is preventing us from getting on with this claim on the premise that the JJC may eventually make a decision that the Dubai court is the right forum. Now, we say that's not a proper exercise of the court's discretion, because the court has no idea whether the JJC is going to say that. The JJC may well say that the DIFC court is the correct forum, and if it does, that stay will have been all for naught. The appropriate,
yeah, sorry.
If the court is worried that it should exercise its discretion in the way just postulated to avoid a situation where there is where it has to deal with the fact that the JJC decides that the Dubai court is the correct forum, that shouldn't happen now. This matter can and should proceed, and if the JJC then brings out a decision which says the Dubai court should deal with it, that is the right time to consider whether these proceedings should be stayed. Because the problem with deciding that now is the following: the first claimant does not get a seat at the table at the JJC. So the first claimant's claim ends up being stayed on the basis that it doesn't get to address the JJC. It's stayed completely unnecessarily if the JJC nonetheless finds in its favour. And there is no impeding threat to anybody of letting this case go ahead. If you let this case go ahead in the DIFC, what will happen next is that the hearing to set aside the default judgment will happen. That undergrowth will be cleared out of the way, and there will then either be a default judgment which the JJC will either have to deal with, or there won't be a default judgment and will be left with two competing court actions. But in either case, it must be wrong in my submission to prevent at least the first claimant from proceeding ahead with dealing with the application to set aside the default judgment now, whilst the JJC is considering what happens in relation to the second claimant's claim. And the exercise of discretion, if it stops the first claimant from pressing on and grappling and dealing with that application to set aside the default judgment, is introducing a delay to the first claimant's resolution of its claim on the premise that at some point in the future, the JJC might decide something. And that, in my respectful submission, is not a fair or appropriate way for the court to exercise its discretion. There is no loss to the defendant to allow this matter to go ahead, because what will then happen is not that we get to enforce our judgment as matters stand, but rather that we will have to deal with the application to set aside the default judgment whilst the JJC is considering matters. So that's the point. What in fact happened in this case is they made their application to set aside that default judgment and thus succumbed to the jurisdiction of this court before they contested jurisdiction. That should
and you'll be arguing that the application to set aside the judgment was a submission to the jurisdiction, so it's then too late for them to object.
Well, I don't even have to argue it. My learned friend has just conceded that in what he has just said about how matters proceeded in the Dubai court. He's just expressly said that's how it works. So I don't think we will have to have much of an argument about that. So as matters stand, we now have, on the basis of the submissions made this morning by my learned friend, as I understood his submissions, he was making the point that given that an application was made before, in this court, at least before jurisdiction was contested, they have succumbed to the jurisdiction of this court. And we agree with that. Of course, if an application of that sort is made by somebody, they're agreeing to the jurisdiction of the court. But the point being that what will be resolved if the first claimant's claim is not stayed is the application that was then made to set aside default judgment. That does not cause prejudice to the second defendant to deal with that, or at least the prejudice in dealing with that is vastly outweighed if the first claimant, having perfectly, properly and correctly obtained that default judgment, is now prevented from grappling with that as we go forward, on the premise that even if the first claimant's claim is not referred to the JJC, the court should simply exercise its discretion to prevent it from getting on with dealing with that default judgment. And so whilst I, of course, accept that the court has a general discretion in terms of stays, that's not, in my respectful submission, an appropriate exercise of the court's discretion. So that general point aside, we come back to looking at the decree and so on. And the point which my learned friend, in his very helpful submissions, did not grapple with was the seat at the table point. In proceeding as they have done, we end up, if he is correct that the decree automatically kicks in on its wording, we're in a situation where they have referred only the second claimant's claim to the JJC. You arrive at the extraordinary position where the first claimant's claim is automatically stayed by operation of the decree, in a situation where it has no locus to actually deal with the JJC at all. Now that can't be right. That can't be an appropriate reading of the decree, because if so, it would lead in many situations to unfairness. And it's not good enough to say, as my learned friend does, well, it doesn't really matter in this case. The decree, the meaning of the decree does not change depending on the case. And so whenever one is looking at whether it's the words proceedings or claim or action, all three of those words, well, the fact that action or claim is used as a synonym in the translations for proceedings then tells you what proceedings means. And it means you do have to look at the claims. And that is why if the defendants wished to halt or stay the claims of the first claimant, they should have made them a respondent to their application to the JJC. Now, saying more than that, as I say, gets into repeating the submissions. But the point I wanted to make is the seat at the table point, which I raised earlier, which is plainly important when one comes to construe the decree, is a point which my learned friend hasn't grappled with. Or at least, as I heard him, I didn't hear him grapple with it. If I missed where he grappled with it, I say it certainly didn't land with me, and so therefore he didn't grapple with it properly. I say that in case I look back over the transcript and realise he did mention it somewhere. But if so, he didn't deal with it properly. And the last point is the positive step point, which arises from paragraph 35 of LACAM and, as you say, the private international law principles. To be absolutely clear, I am not saying that in order for a court to exercise jurisdiction in a case, it has to positively address itself on whether or not it has jurisdiction. It doesn't have to say, I've been asked to consider whether or not I have to take jurisdiction. But it does have to make, the court does have to take a positive step to assert jurisdiction. And the step it has taken of simply applying the stay, which it has done, and refusing to lift the stay, is not such a positive step. It's not such a positive step because one only has to look at the judgments by which it applied that stay to see that what the Dubai courts have done is said, right, you put in a submission that has flagged up this JJC point. If you file, if there is an action filed in both jurisdictions and is referred to the JJC, we have to give a stay, and that's what we're doing. The court, in granting that stay, was positively not saying whether or not it had jurisdiction. So that's a nuance. I am not adopting the extreme case that in order for a court to have jurisdiction, it must ask itself the question, do I have jurisdiction, and answer it. Of course, if it does something which shows that it has accepted jurisdiction, that is sufficient.
What about the application? What about the refusal of your application to withdraw the proceedings? Isn't that a positive exercise of jurisdiction?
Well, no, in the sense that all that has happened, it is apparent when you look at what the court has done, that it has granted a stay in relation to the first action. It hasn't even considered, which is the Orient Takaful case. It hasn't even considered that application.
Right.
All it has done is stay it. In relation to the second case, which is number 28, the Qatar insurance case, I set out at page 12, subparagraph 19d, the extract from the court's judgment, and it is clear in the court below that the court equally did not consider the application, it simply stayed the case. In the Court of Appeal, in that second 28 Qatar case, the withdrawal application is mentioned and dealt with, but dealt with on the basis that the claim was stayed. The Court of Appeal said it was maintaining the stay, and one of the reasons was because it wasn't allowing us to withdraw. And in that context, not allowing us to withdraw, I say, in that specific context of doing so on the basis it was maintaining the stay, isn't an exercise of jurisdiction, because it was part and parcel of the court deciding that it was going to maintain the stay and put it all off to the JJC.
Is the decision of the Court of Appeal in the hearing bundle?
It is at K254.
Right.
Now, it does, and as I say, and the reason I wanted to specifically flag it up in my skeleton so that the court wasn't misled, the court in that case does, in fact, consider the withdrawal application, but only at the Court of Appeal level after the stay is put in place, and only as part and parcel of considering the stay. In the Orient UNB 27 case, we've only got the first instance decision, and it's quite apparent whenever you look at the the court's decision that it doesn't even consider the withdrawal application. It simply stays matters.
Okay.
So at least in that case, at my absolute worst, at least in that case, there can be no sensible suggestion that my learned friend can, and again, I don't slag him off, I jump on bandwagons all the time, but that's not a bandwagon he can jump on,
Yes,
because that's just not what happened whenever you go and look at the judgments.
Right.
So those are the 4 points I thought I could usefully deal with in reply without simply repeating what I'd said before. But of course, I'm very happy to deal with any other issues. Which
as I mentioned earlier, I think council have been very effective in helpfully identifying for me the key points of difference between the respective arguments on top of the skeletons, which I also found very helpful. So I'm grateful to both council for their assistance. As you will possibly be aware, this isn't the only case that's emerged from Lacan. I think it's fair to say Lacan has put a bit of a cat in amongst a big flock of pigeons, and the pigeons are fluttering every which way. For that reason, that's my justification for reserving my decision and using the language that I use in giving my decision carefully, because I know that people are looking carefully at the precise words used, as indeed you've both done in relation to the words we used in Lacan. So I will take time to consider the issues and make sure that I use language which is as felicitous as possible for all those who are watching on. Hopefully that won't take me too long. I would hope within the matter of 2 weeks or so I should be able to get something out. But I do want to see the transcript, and that'll take a little while, just so that I make sure that I have given full attention to all of your helpful arguments. So that'll probably mean a couple of weeks, but I'll publish my decision as soon as I can. Thank you, everybody, for all your assistance.
Thank you very much.
Court will now adjourn.
Thank you very much.
Thank you.
Thank you.